Okay, so lobbying being often about sectional interests. And because of that, in the world of lobbying, there are often winners and losers. So again, there's a big campaign going on in the United States and Canada at the moment around an oil pipeline. And there are lobbyists on both sides of that argument, trying to persuade the American and Canadian governments to allow the pipeline, and others are trying to lobby the governments against the pipeline. Sooner or later, depending on whether the pipeline is built or not, some people will feel that they have won and other people will feel that they have lost. Another aspect of lobbying is that it usually is about seeking an advantage for me personally, or more likely my community, my company, my constituency, but some sort of relatively narrow or defined group of people. And often that is in competition with another community or another constituency or another group of people. So you can see that lobbying has this kind of competitive aspect to it. Now, these things are not necessarily wrong. It's not wrong to pursue a sectional interest. It might be a very, very justifiable thing that you are doing. The interest may be a very important interest. And it is also true that, unfortunately, sometimes there are winners and losers in our social arrangements. Sometimes it's not possible to avoid that completely. It's also not wrong necessarily for people to seek advantages for their community or for their constituency. It may be a community or a constituency which has been disadvantaged for a very long time, and it deserves to have a particular advantage. So I'm not saying that lobbying is always a negative thing or somehow a thing to be looked down on, but it is different from advocacy. Advocacy is first and foremost about speaking on behalf of others. If you think about the advocate and the lawyer who is an advocate in court, the advocate in court never speaks for himself or herself. They always speak on behalf of their client. So they are using their particular training, skills, and knowledge of the law on behalf of someone else or some other cause, in the legal sense, a client. In the kind of work that we do, advocacy is not selfish or competitive. It's not selfish in the sense that we are not seeking to promote our own personal or organizational interests when we go and do advocacy. We are speaking on behalf of somebody else. And we're not, in the sense of lobbying, trying to compete with another direct kind of interest. We are, if you like, trying to highlight the needs and perhaps the rights, entitlements of a particular group of people or class of people or a particular cause which needs to be spoken about, or which perhaps cannot adequately speak for itself or for themselves. Sorry. Advocacy upholds rights and promotes the common good. This question of upholding rights, I think, is an important distinction again, because lobbying often, not always, but often, because it is seeking some sort of an advantage, can go beyond simply rights and try to grab, if you like, more and more and more on behalf of that interest group or that particular community. Whereas real advocacy focuses on rights, and in particular on the fact that a certain group, perhaps, or class of people have been denied their rights. And I think you can imagine this quite easily when we talk about refugees and migrants, because they are one of the groups everywhere in the world that tends to have their rights violated or in some way constrained. And doing advocacy on their behalf is not asking for special treatment. No one suggests that migrants and refugees have more rights than citizens do. What we're doing is trying to claim or uphold their rights that are being denied to them. So if you like, lobbying sometimes asks for more than what is a person's right, whereas advocacy is about upholding the rights that they deserve. And advocacy also then promotes the common good. When you are in a competitive situation, you're not really interested in the common good, you're interested in your own good, or again in the good of that narrow sector on whose behalf you're doing the lobbying. Whereas advocacy is about finding the rights of the particular group within the context of the common good as a whole. That notion of the common good, of course, was also something that Peter John spoke about yesterday when we're talking about the Catholic social teaching approach to these things. Just give me a second, sorry. Micheline? Okay, just hold on. I'm just checking whether everybody is still able to hear me. If you can indicate, please. Micheline, our translator, seems to have a problem. Okay, so people can hear me.
Jean-Paul, pouvez m'écouter?
Oui, Jean-Paul.
Oui, Jean.
Okay.
J'entends pas Jean-Paul.
Raymond, if you're able to take over the interpretation.
Yes. Allô?
Alors, je vous écoute.
Je
vous
entends. Tu m'entends maintenant, papa Jean-Paul? Bonjour, papa.
Je t'entends depuis longtemps.
Ok. Oh, il m'entend. Papa, sorry, Mike, you can hear me?
C'est ça.
Jean-Paul, can you hear me?
Je vous entends.
Ok, merci.
Oui. Okay.
Mike, can you hear me, Mike?
Yes, I can.
Yeah, and Jean-Paul said that he can hear me as well.
Good.
But we just have, Raymond, we have to make you an interpreter so that
yes,
everybody else. Megan, will you do that?
Yes, I have. I've requested, it should appear on your screen, Raymond.
Yes.
It should say that I have appointed you as an interpreter, and then you need to accept it.
Oh, okay. There's nothing coming on my screen. Okay, can
Okay, I'll try again.
Okay.
Do you see anything now?
Yes.
Okay.
There it is.
Just accept that.
Good.
Okay. So I think that we can proceed. Sorry about that delay, everybody. That seems to happen with technology. Just please remember to mute yourselves.
Envoie-moi les photos et puis
Or Megan, if you can mute those who are...
Patrick a payé son Vodacom. Vous n'avez pas ça?
All right, I'm going to continue. And if there's any problem, please just highlight it in the chat box. So I was saying, advocacy finds the rights and the entitlements of the group concerned within the common good, rather than against the common good. In that sense, it is not greedy or selfish. So those are, for me, some of the key distinctions between advocacy or lobbying. I say again, I don't want to make too much of this question, but I think that it is something worth thinking about. And it helps us in the way that we frame and think about what we do when we do public policy advocacy, to think we are not in competition with other people. We're not trying to, if you like, grab a bigger slice of the available cake. We're not trying to fight people in order to get a bigger share of resources. What we're trying to do is to make sure that those on behalf of whom we are doing our advocacy receive what is rightfully theirs, protection of their rights and entitlements, just like everybody else. And if we do that, we should be able to enhance not just their position and their interests, but the common good of the whole society. So moving then to the second part of my presentation, the constitutional and legal approaches. So advocacy identifies and claims rights. And that word rights immediately brings us into a constitutional framework and into a legal framework. Rights are, if you like, about law and how the law is working or failing to work. It's about what the Constitution grants us, or if you like, which rights are recognized by a constitution. And it's very much about whether the Constitution, and I think all our countries have a constitution, whether it is simply something that exists on paper without ever being implemented, or whether it is a real and living and powerful force in our country. Those of you who are familiar with your own constitutions will know whether it's something which is dependable and actually used, or if it is something which is merely written on paper and never actually brought into being. But either way, advocacy starts off, if you like, by identifying the rights, the entitlements that the particular group should have, and then saying, well, do they or don't they have them? And if they don't, then there's work to be done. Advocacy follows a legal path, and I've put in brackets there, law-centered. And what I mean there is that it's not a question of saying something is legal and something else is illegal or unlawful. I'm not getting into that kind of a debate because, again, depending on the political circumstances in your country, you may sometimes need to do things which, strictly speaking, are illegal or unlawful or somehow outside the law of the country in order to pursue your advocacy. In other words, if a government has so violated the law or perverted the law in various ways, you may find it impossible to follow a strictly legal path. But I would say you are still following a law-centered path. Your intention is to make use of the existing law, or the law as it should be, or the law as it should be implemented in order to pursue your advocacy. So advocacy is not just waking up one morning and thinking, well, wouldn't it be nice if these rights could be given to those people? It's not about nice to have things and about whims, and it's not a kind of daydreaming sort of thing. It's not about fairy tales. It's about rights. It's about the legal ways of ensuring those rights, of exercising those rights. And it's about, in many ways, legal mechanisms. As we'll see later, much of the advocacy that we do is around the formation of laws and the writing and the drafting of laws and public policies. So that all for me is covered by this idea of advocacy, following a law-centered path. And advocacy demands things like fairness and justice and consistency. Again, advocacy is not about trying to grab what you can when the going is good. It's not about trying to promote one set of interests over and above another set. That wouldn't be fair. It wouldn't be just. Advocacy looks for people getting what they deserve to get in terms of who they are, what their status is, in terms of the law, in terms of the Constitution, and in terms of their particular needs. So again, for example, we know that migrant populations often have greater need of resources and protections than local populations, simply by virtue of their disadvantage. They have left their support systems behind. They've often had to leave all their resources, their money, and so on behind in the country from which they have fled. So they may have special needs, they may have different needs from the local population. But all that we are asking for is fairness in the way that those needs are met. And if you like, fairness and justice and consistency are all point in the same kind of direction. What point I'm trying to make is that advocacy is not asking for special treatment over and above, not asking for better treatment. That's what lobbying might be doing. But advocacy doesn't do that. Another important aspect of advocacy when it comes to this constitutional and legal approach is that when we do advocacy, we actually participate in democratic governance. We take part. Why? Because one of the things we're trying to do is to improve governance. We're trying to make things better. If there was no need to make a particular aspect of governance better, there would be no need to do advocacy around it. It would be perfect. It would be satisfactory. But we find that, for example, some aspect of governance of the environment is not satisfactory. And so we do advocacy about that. And in doing so, we participate in trying to make that part of governance better than it was. And as citizens, we have the right to participate. We'll talk about a participatory democracy. That is a democracy in which the citizens take part in decision-making all the time, not just once every 5 years by voting for a parliament or a president or a new government. We also take part in the business of governance on a continual basis between elections. That is what democratic governance is about. We help to create good laws and policies, or to undo bad ones. And those are equally important. We probably spend more time trying to work on the creation of good laws and policies and doing our advocacy around the need for a new law or a new set of policies. We should certainly pay as much attention to the need to undo bad ones and to identify those that are not working in the way that they should, or laws which are having undesirable effects on the people on whose behalf we're doing advocacy. But either way, whether we're helping to make good laws or helping to undo bad laws, we are taking part, we are participating, we're getting ourselves involved in that process. And if we do that, we find that we are helping to build a well-functioning democracy. And for me, this brings up, if you like, the sort of secondary purpose of advocacy. You might be doing advocacy primarily in the field of refugees and migrants. The next organization is doing advocacy in the field of women's rights. And then there are those who do it for children's rights. And there are those who do advocacy for environmental concerns, and so on and so on. And we all know there are hundreds of different fields of advocacy. Carrying out advocacy, no matter whether we succeed or we fail in the particular point that we're pushing about our particular interest area, the fact that we're doing advocacy, that we are interacting with the political and the legal authorities, for example, parliaments, governments, means that we are building a well-functioning democracy. So when I say it's a secondary aspect, it's not that it's unimportant, it's vitally important. But the thing to bear in mind is that simply by doing your advocacy, whether or not you feel at the end of the day that you have succeeded in winning the particular right or entitlement that you were asking for, the mere fact that you have been engaging the authorities and that they have been listening to you and taking you seriously, the mere fact that there is a space that you have created in order to do that means that you are helping to build a well-functioning democracy. I want to illustrate that with reference to a small diagram, which I hope will be big enough for you to see. And this is a very rough illustration. This is how you can think of a well-functioning democracy. In the center, you have your democratic parliament and the organs of government, all the different government departments and ministries and institutions and so on. And that circle in the center, parliament and government, is always subject to what you could call forces of influence. So the outer circle is the circle of the different forces of influence. And on the left-hand side in the blue, you have what we could call the sectoral interests. That is, things like political constituencies, business and industry, the big geopolitical forces like foreign governments and tendencies. We talk about the West and the East and the Middle East and so on, Third World, etc. There's things like the G20 and the G7 countries, all of those things. All of them are trying to pull that democratic center in a direction which favors them, because they are almost all of them sectoral interests. On the other hand, on the right-hand side, you have civil society, and in particular the faith community, which is where we are concerned, which is also trying to pull, or shall we say, exert an influence on Parliament and the organs of government. But the agenda of civil society and the faith community is different, or at least it should be different. It should favor the common good rather than sectoral interests. If the various forces of influence are more or less in balance, as they are in this diagram, then you have a well-functioning democracy. The sectoral interests have a right to exert influence on government. It's not wrong that they do that. And the common good interests also have a right to do so. And these things, as I say, if they're held in balance, then your democracy is functioning well. I've added in green there the question of the media, both local and international, because that is the way in which almost always we get to learn about what is going on in the middle, what is going on with our parliament and our government. And we get to understand whether indeed it is being unduly influenced by some of the sectoral interests. People like us who work closely with Parliament may have our own sources of information, but for the population as a whole, the media plays that role for them. And of course, under media, you can include their social media. Now, what happens when the democracy is not well functioning, when these forces of influence are not in balance? What you find almost always is that one or other of the sectoral interests has managed to, as it were, pull Parliament and government away from the center, away from a position of independence, of its own autonomy. It is now under the undue influence of particular sectoral interests. Here in South Africa, we experienced that very, very strongly during the presidency of Jacob Zuma, where a range of commercial business interests, the famous Gupta family and others, managed to capture much of government and even of Parliament. Many of you will have heard that phrase, state capture, where the processes and institutions and organs of the state were bought through bribery and other means by these largely business interests. And suddenly we found that they were able to exercise great influence over the way that government and Parliament went about its business. And then a gap exists between the common good and Parliament and government. Those organizations that pursue the common good, the ones that I've labeled civil society and faith community, no longer have the influence that they should have, because the politicians are busy paying too much attention to sectoral interests, particularly sectoral interests that have a lot of money. And very often this goes hand in hand with a kind of control or a muzzling of the media, so that information doesn't get out, reliable information doesn't get out. And again, in our country, we saw this happening with the way in which the Public Broadcasting Corporation, the South African Broadcasting Corporation, which controls most of our television and radio, was very much part of this process of state capture and was, if you like, feeding the people with misinformation and lies about what was going on in government and in Parliament. So these are just two very simple, almost crude diagrams to try to illustrate the situation that we ought to have, where Parliament and the organs of government are doing the work that they should be doing in constitutional and legal terms, and where the forces of influence on them are in the proper balance. And on the other hand, where that balance has been disturbed, and we find that it is no longer the common good which is being served by Parliament and government, but rather certain sectoral interests. You'll each be able to identify, I think, where your particular countries fit in terms of these illustrations. Last couple of words about why parliaments in particular matter, and I quote here from the South African Constitution. Section 42 says that the National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. You can see there are three tasks there given to Parliament. One is that it must be a national forum for public consideration of issues. Secondly, it must make laws, pass legislation. And thirdly, it must oversee executive action. It must check what the government is doing, all the government ministries and so on. And in each of those aspects of the work of Parliament, there is room for advocacy from our side. Parliament is the most important, if you like, forum and focus point for advocacy. As I said earlier, in your particular work, you may find that you need to do advocacy at a regional level or at a state level or a provincial level or with a town council or whatever. It's all advocacy. But where we should really be aiming, if we at all can, is at our national parliaments. They are the, if you like, the most powerful legislative forums in each of our countries. Without there being good national legislation, it's very difficult to have good subsidiary legislation. And it's very difficult to get officials lower down in the system to do the work that they should be doing unless the correct laws have been passed in Parliament and unless Parliament is carrying out its duty of oversight over what the officials are doing. So I don't want to repeat myself too much. I'm aware that for many of you, access to parliaments is extremely difficult, maybe even impossible, but I still offer this as at least an ideal situation and as a way also of saying that wherever it is possible, you should try to focus your advocacy as much as possible towards your national parliaments. Moving on to the third part of the presentation, some techniques and principles. There are many. You could probably write books about the techniques and principles of advocacy. I want to concentrate just on 6 points that I think are particularly important and useful. The first one is to say, and these are all written as do's and don'ts. The first point is to say, don't see Parliament as the enemy. You're going there to persuade people, not to have a fight. Again, you could substitute for the word Parliament, don't see your town councillors or your traditional leaders or your political parties or whatever it is. Whatever institution or group of people is the target of your advocacy, don't treat them as the enemy. If you do, you are unlikely to make them see your point of view. You're unlikely to win them over with your argument. You will instead get into a fight. Now, I'm not saying that you must never have a fight. Sometimes that's exactly what is needed. There needs to be a fight to assert rights or to claim rights. And there are many, many ways of having those fights, from public demonstrations and protests and rebellions and all sorts of things, depending on the kind of political circumstances that you find yourselves in. We are seeing it at the moment in various countries around the world where there are massive popular rebellions against oppressive governments. But we're talking about advocacy. And advocacy has its own ways and means. Often, parliamentary advocacy of this kind goes hand in hand with, shall we say, more militant activities out on the street, marches and demonstrations and so on. And they can work very well together. But it's a good idea not to confuse the two things. They each have their own place. They each have their own strategies and tactics. And what we're talking about this week is advocacy. So start off by realizing that you are trying to win an argument. You're trying to get some people, politicians or government officials, to listen to you, to take you seriously. And you, hopefully at the end of the day, you're going to persuade them to agree with what you are presenting to them. In order for that to happen, do respect the institution and the members of that institution. That institution could be Parliament, as I said, it could be a town council, it could be a government ministry, whatever it is. But respect it. If you live in a democratic country, then there's all the more reason to respect it, because it is part of that democracy. It is part of the will of the people, a democratic parliament. And the members of that parliament have been elected, we hope, in a free and open election. But even if you don't have a truly democratic parliament, and even if you don't really trust the result of your elections, you still need to do your best to understand and to follow the procedures and the conventions of that institution. It's not going to help your advocacy if you go into Parliament and the first thing you do is to express how much you disrespect it. People are not going to listen to you. You are really just wasting your time. So find out how the place operates. So they be respectful to the people there, the members of the parliamentary committees, the chairperson that you are working with, the staff of the place, and so on. Don't go barging in and behave rudely or refuse to follow procedures. You are simply, again, not going to be listened to, and an advocate who is not listened to is just wasting time and energy. The third point is, don't only complain. It's important that you give praise and support where it is due. So, for example, you may be looking at a new law or a new set of regulations that your government has published, let's say, to do with refugees. And you may immediately identify 3 or 4 points that you want to oppose. Fine. Part of your advocacy is to go off to Parliament or to the government department and explain why you oppose those points. But try to find other points which you can support so that you show a balanced approach, so that you show the target of your advocacy, Parliament, government, whoever it is, that you haven't only come to moan and complain and to bring up negative points. You also recognize that some of what they're doing is positive and you are there to support it. Another way of thinking about that is we tend, all of us, to want to make a submission to Parliament or to do our advocacy when something bad happens. But when things are going well, we tend to remain quiet. We say nothing. Of course, we've got nothing to complain about, so we just keep quiet. And that is a problem. we should look for opportunities of giving praise to our parliaments and to our lawmakers and to our governments when it is deserved, when they have published good laws or when they have implemented good policies. From a tactical point of view, that also ensures that you will be listened to next time you come with a real complaint. Because people will remember, oh yes, they were here a month ago or last year and they were praising us. Now they have a problem with us. We better listen. We better take them seriously. Whereas the people who only ever complain, eventually no one listens to them. Don't be partisan. In other words, don't ally yourself as a civil society organization, and above all in the faith community, with particular political parties. If you do that, you will lose credibility and you will always alienate people who support other political parties. Now you find that politicians often try to paint a picture that says a particular civil society organization or NGO is allied or somehow connected with the opposition political parties or with the communists or with, you know, whoever it is, the fascists or something, the counter-revolutionaries. That's something that is often said in this country. Don't ever give them the excuse to make that claim about you. Don't go to Parliament and say, you know, we would like to support the view of the opposition on this point. And similarly, of course, don't go to Parliament and say we want to support the view of the governing party on this point. You risk being identified with a party. All the other parties will start to ignore what you have to say. The fifth point is do your research properly. Make sure you understand the legislation or the policy that you are dealing with. And more broadly than that, make sure that you understand properly the issues that you are dealing with as someone doing advocacy. Okay? Again, I've seen it many times that people go to Parliament and they claim certain things. Either they claim that certain things are in a law, when they are not in fact in the law, or they claim that the law means such and such, when in fact it means something different. Or people go and quote figures and statistics and facts, and they do so inaccurately. And then the members of Parliament or the government officials point out the inaccuracy. They point out that you've made a mistake. Well, you immediately look fairly stupid. And immediately you lose your opportunity to impress them with your position. You haven't done your research properly. And I think it's something which affects many of us who are very committed to our issues, that we kind of rush off to make our statements and to make our submissions sometimes because we think we know what we are dealing with. Take your time, make sure that you actually know properly what you are dealing with, and then that enhances the possibility that your submission, your argument, will be taken seriously. And lastly, make sure that you are brief and clear and focused. Now, I'm talking here again mostly about parliamentary advocacy, but it counts also, I think, for all kinds of advocacy. Members of Parliament and high government officials and ministers and things like that don't have time for long and rambling and confused submissions and arguments. I have often seen in our Parliament people presenting thick dossiers of information, 50, 100 pages. Nobody reads those things. Nobody reads them. Members of Parliament definitely don't read them. Whereas if you come to Parliament with a 4 or a 5-page document in which you set out your argument very clearly and very concisely and in a very focused way, the chances are that they will read it and take it more seriously. That's not to say that the other person's 100 pages is nonsense. It might be excellent, but it's a textbook, and these people don't have time to read textbooks. So be brief, be clear, and be focused in your advocacy. I'll conclude now with just briefly with a summarizing of the 3 aspects. Firstly, advocacy versus lobbying, the distinctions. When we do advocacy, we are speaking on behalf of others, and we assert their rights, and we aim for the common good. The constitutional and legal approach. Advocacy follows a law-centered path, and it participates in the creation of better laws and policies. That word participate is very important. And then the key techniques and principles. We seek to persuade. We are balanced and non-partisan. We are professional. We do our homework. We do our research. We are respectful. And we are clear and focused. And that is it. Thank you.
Please sign up for our newsletter at cplo.org.za.